Novelty is not the only test. In fact, the non-obviousness test, or what we call the inventive step, this is called the second step in patentability, that the invention should involve an inventive step. The same definition deals with this. Now, this requires something more than a prior art search. Now, in the prior art search will actually be looking for an exact description as yours in the prior art, which sometimes is very hard to get. If you had used a particular embodiment which was not there, or which others could not think of, or if you had used a new material which was launched only last year, and if you give a description with this new material, it is quite unlikely that you will pick up patent applications, pending patent applications or granted patents, because of the mere fact that you have now used a new material. Now, the new material that you have used will definitely make your invention novel, because nobody else had used that material in creating a mechanical device. It gets over the novelty search, because if you go to the databases, patent and non-patent databases, this material, because it is just launched very recently, you would be the first person, at least when you do the search, you will find that you are the first person who is having a new application for this material. Little does it mean that it will also satisfy the inventive step criteria, because the inventive step criteria goes beyond a mere matching of what you call disclosures. Your disclosure is matched with a prior disclosure. If all the elements or integers are not matching, you satisfy the novelty test. The inventive step test is something beyond that, because in the inventive step test, you bring something other than just matching documents. And this is important for you to understand. You bring the common general knowledge, okay? Common general knowledge a person skilled in the art has. This mental element, I'll call it the mental element. This mental element is brought into the inventive step requirement. This mental element is not there in the novelty test, because in the novelty step, your description, if it has a new embodiment or a new material, and all the prior art does not have that new material, you satisfy novelty for the sheer fact that your description as you have defined it has not been disclosed before. So, just by adding a new element, you would be able to get over the novelty requirement. You will be able to you will be able to make your invention as a novel invention. The inventive step requirement, as I said, there is a mental element involved in the inventive step. Now, we are just not looking at the databases, the prior art, the patent and the non-patent databases. We are not just looking at that. We are also looking at the ability of a person skilled in the art. I'll come to a moment as to what the person skilled in the art is. We are also looking at the ability of a person skilled in the art to match things from the database, take things from one place, take another document from another place, read them together, and to come up with that invention. Now look at that. In the first test, we were essentially looking at matching documents. I would be very careful to say that, because novelty, as I mentioned, could also involve prior use. And I mentioned very clearly that publication is one way to show, prior publication is one way to demonstrate lack of novelty. Prior use is another one, though it is difficult to prove. So, but today most patent office don't go by prior use. They only adopt prior use if it is published, because what a patent office would normally do when you file your application, they will go to this patent and non-patent databases, they will run a search, and they will give you a report saying that your invention is novel. So, they are not actually going to look or file or ask for testimony of people to say that yes, this particular gadget was used 10 years ago, I witnessed the use in an exhibition. If it is not recorded in a publishable form, the patent office will not immediately look at it. There are other ways in which you can bring it in a post-grant opposition or in a revocation proceeding. The same thing can be bought, but prior use is not taken seriously if it is not published. So in today's practice, when we look at novelty, the novelty check is essentially a check of published documents. So novelty, again to reiterate, is a test of published documents, but inventive step, it is not just a test of published documents, it also involves the mental element, or what we call the ability of a person skilled in the art to weave things together. Let me put it that way, to weave things, to club things and bring things together. In some books you would have said mosaicing, mosaic, to make a mosaic out of documents. So inventive step should always be understood as, it's just not a database check, it is, yes, a database check and the ability of a human being to read things together. So even if you used a new material, we mentioned that to satisfy the novelty test, you used a new material which was recently released and nobody else used it for this particular application. So you satisfy novelty, because no matter what search you do, the new material, and in this for using this particular in this mechanical device, nobody had used it. You were the first person to use it. That makes you satisfy the test of novelty. But when it comes to the inventive step, again, a database search will show that this particular new material has not been used in a mechanical device. But the inventive step will ask a further question. It will ask whether it was obvious to a person skilled in the art. That's a third point in the slide which you can see here. When you ask this question, you are essentially asking whether the person skilled in the art, as I said, the person skilled in the art can vary in different fields. In mechanical engineering, it could be a person having the skills of mechanical engineering. In biotechnology, it will be a person with biotechnology skills. So depending on what the invention is, the person skilled in the art. Look at the person skilled in the art. Again, it's a concept which we'll be discussing in greater detail. The person skilled in the art is the person to whom the invention is addressed. Now, he is the person skilled in the art. Because if you are writing a patent specification, it is addressed to him. It is not addressed to the general people. Because if you are writing a patent specification involving a antibiotic combination, a composition having multiple antibiotic combinations in a particular dosage form. Now, this is not addressed to the general person. It is not even addressed to a doctor or a physician. It is actually addressed to a person who is into formulations, who is able to understand the chemistry behind it and who develops these drugs. So all patents are addressed to a person skilled in the art. And as I said, depending on the technology, that person will vary. Sometimes, depending on the technology, especially when it happens most of the time today, it could be people from different technological fields. They could be if you are using paint technology, okay, how to make emulsion paints, and you are also involving nanotechnology to it. It would, now the person skilled in the art would not only have the skills of developing emulsion paints or paints that are used on automotives, he would also have some skill on nanotechnology, because you are using nanotechnology into this field. So it will be many a times the person skilled in the art in the modern world is a team of people. You understand how R&D happens, so you will be better informed to know that when we are talking about a person skilled in the art, we are actually, in today's context, we are talking about a group of people, because very rarely we find patents filed by individuals, especially at the high level technology. And it's the same reason you don't find scientific literature coming out of single individuals. You don't find that. Most of the top, you can take any journal, Science or Nature, you will find that most of the journals are, the articles are written by a group of people. So today, research endeavor is an endeavor which takes many people, sometimes from different disciplines, coming together and creating an invention. For this reason, the court and the patent office understands a person skilled in the art as not just one person. Depending on the technology, it could be a group of people. It could also be a group of people working from different parts of the globe. I can show you some case laws where the court actually came to a conclusion that it could be a group of people in say some leading pharmaceutical company may have its R&D centers in 4 or 5 places in the globe, and they could be interacting and working together. So it could also be people who are physically and geographically separated, but still could be a part of the team. So when determining obviousness, you bring the person skilled in the art into the picture. So now if somebody asks you this distinction, for me, obviousness and inventive step and novelty looks the same. Novelty, you do some checks and you say it's novel. Inventive step, you do the same check. You check the same data, same databases. Now, if somebody asks you what the difference is, this will be your answer. You will say that in a novelty test, the invention is matched with what has gone before. So the matching is done, and if the invention has a new element, it gets over the matching. Whereas in the inventive step requirement, you will be seeing the invention from the perspective of a person skilled in the art. So you bring the human element, what I refer to as the mental element. Earlier on, it was just matching of databases. Here, it could be, let me explain this to you. Now, I mentioned that you had come up with a mechanical device with a new material. You are the first person to use that material. The knowledge of the material is there in the prior art, and the knowledge of the mechanical device is also there in the prior art, but nobody has matched them together. You are the first person to use this particular material. It's a new material for this mechanical device. So you get over the novelty step because no databases throws this combination. You are the first person to do it. When it comes to the inventive step, you will be asked, or your invention, because of your background, because of your technology, they will be asked whether a person like you, that is your competitor or a person who is in the same field of view, whether that person would have been able to match these two information that was there in the public domain. There was invention, there was knowledge about the mechanical device, it was already there in the prior art, and there was knowledge about this new material. Now, if after the analysis, the patent office or the court or the intellectual property appellate board, these are bodies which can actually do this determination. If the court or the patent office comes to the conclusion that yes, your competitor, who is a person skilled in the art, could have read these two documents, the document showing the new material and the document showing the mechanical device, and it comes to the conclusion that it would have been obvious for him or for that person to combine this, then inventive step is not proved. If the patent office comes to a conclusion that these two documents, yes, they were different documents, they were not in one document, which is a requirement for novelty. Both the entire description as you have described should be in one document, it should be in one place. Now, because they are in two different places, the patent office or the court will ask this question: was it possible for a person to combine these two things? Combine mentally, that is, combine these two things and come up with that invention. If the court or the patent office comes to the conclusion that yes, it was possible for a person skilled in the art to combine these two documents and come up with the invention, then the court or patent office will hold that this does not involve, the invention does not involve an inventive step. Now, I hope this point has come out clearly. So, the difference between a novelty check and an inventive step check is the inventive check involves the mental element. Mental element is the ability of a person skilled in the art to weave things and read things together. Now, the person skilled in the art is also attributed. This is apart from his ability to read two documents together. A person skilled in the art is also attributed with the common general knowledge. Now, common general knowledge could be a long list of things. It will change from industry to industry, it could change from technology to technology. Many things what we call tacit knowledge, knowledge that is there, the workman has it, but the institution or the industry has not captured it, it's not published anywhere. Many things that pertain to tacit knowledge, the way in which you start a particular mission or the way in which you hold back for a few seconds for something to dry. All these things may not be captured in the literature, it may not be in a published form, but nevertheless, this could be something which would form a part of tacit knowledge. Now, many of you would have been as a part of your chemistry course, either in school or in college, you would have been to a chemistry lab and you would have used the pipette. Now, there are ways in which you can use the pipette. There'll be some smart way in which you can use it so that it does not drip much. All these things you may not find in a textbook. A smart way to use the pipette to ensure that it does not drip or to get the measurement right. These are all part of a tacit knowledge. And in industries, I mean, there are n number of instances where we can say that tacit knowledge becomes a huge big part. That's one of the reasons why companies are very careful in not losing out their people, because when people leave, they also leave with quite a lot of tacit knowledge they have. The published knowledge is always there for people to read and come up to speed, but the tacit knowledge is something which a skilled person leaves, he leaves with it. So the person skilled in the art is also attributed this common general knowledge, which includes also tacit knowledge. So because he is attributed with the common general knowledge, he can, if combining two things, a new material with an existing mechanical device, if he could have perceived it without much experimentation, without undue effort, then the court or the patent office will hold that this invention did not involve an inventive step. Now, I'd mentioned that inventive step is the most potent ground under which invention can be challenged, and in history, in patent law history, we have seen that most inventions have been challenged successfully using this ground. So this is the most potent ground because it brings something as enigmatic as a knowledge of a person skilled in the art. It's not defined anywhere. You don't say that it's just the published knowledge, which is something which you will look for in the novelty test. Here you say anything that is in the common general knowledge, and common general knowledge is not defined, and anything that can be attributed to a person without undue experimentation becomes a part of a knowledge which that person has. So it becomes very hard for inventions to get over this, and this is precisely the reason why the inventive step has been the reason why many inventions have been revoked, or many patents have been revoked using this ground. Now, the inventive step requirement, apart from being obvious to a person skilled in the art, in India, it also requires technical advance over existing knowledge, which you can expect any invention to have, because inventions, for them to be involved in inventive step, and I mentioned inventive step is something that is not an ordinary step. It's not a logical step. Now you do A, B, C, and if D is where every person in the art is going to move forward, we don't call D as an inventive step, because every person who has threaded A, B and C would automatically take D. It's the logical process in a particular field. We don't call that A, B, C and then D. We don't call that an inventive step. Inventive step is the step which most people don't take. And somebody takes that step, and there was every reason for him not to take that step. The existing knowledge directed him towards D. The people, whoever whose colleagues were all would have done D, but he ended up doing E. And E gave him a product which made the product qualify for a patent. Now, most of you know the example of Alexander Fleming, the scientist who invented penicillin. Now, he did something different from what others did. Whenever their samples got corrupted, every scientist threw the sample into the dustbin. He went ahead and examined it and came to some conclusion. Now, that's an example of what an inventive. It's very hard to put inventive step into such straitjacketed examples. You will understand as we go by, because there's quite a lot of details to it. But normally, what courts will look at is, was it something which a person in a field could logically be expected to do? If a person in a field could be logically be expected to do, we don't attribute that as an inventive step. So what the language, what a person would logically would do, is captured as obvious. Logic, obvious. What is logic? Obvious to a person. So if it is something is obvious to a person, A, B, C, and then take D in that particular field, then we don't call that to be an invention. Rather, we say that that is an obvious step. It's not patentable. Now, technical advance would mean that you the entire scientific knowledge is built on peaks. There is a scientist may come and plant a flag over a new peak and say that this is my disclosure, I have found something new, and he may plant a flag there. That's a new point. Now, if a scientist has to come to an improvement over that, another group of scientists or one scientist, he would come up and say that now I have planted the flag further up in a new peak, and he'll say that this is my discovery, and he would plant it in a new place. So constantly science is moving forward, and this is what we call a technical advance over existing knowledge. A technical advance is essentially where the new knowledge is created, and new knowledge is created where people went and pegged the flag in a new place to say that we have found this and we are disclosing to the world. Now, this new knowledge should manifest itself in the form of an invention. Otherwise, it will be a scientific discovery. Many times, you know, even as we speak, new species of plants are being discovered, new species of animals are being discovered, new places are being discovered. Now, scientific discoveries of plants, living and non-living things is only a scientific discovery. It does not become something patentable, something which we'll be looking at today. So, for something to become patentable, it should also be in the form of a product or a process, an invention. So, technical advance over existing knowledge is one requirement. If you can't satisfy that requirement, you have to show economic significance. Now, economic significance is actually utility. It's the language of utility. Something should be useful and people should be willing to pay money for it. It has got a significance in terms of money. Now, these two requirements, I must tell you, are not the classic requirements. Earlier, before the Patent Act was amended, that was before 1995, we did not have technical advance to existing knowledge or economic significance as a part of the definition to inventive step. It was not there. It was introduced later in 21JA. You can see the amendment. You can see the date on which it was amended. It was introduced at that point. It was not there before. So this has created some criticism saying that obviousness is easily understood, and elsewhere in Europe and in the United States, it's still the obviousness is understood as something not obvious to a person skilled in the art. Technical advance and economic significance is not there. So it has led to some criticism saying that this is not actually required.